Hello students, after discussing the law relating to Hindu, Muslim, Christian and Parsi weddings, today we will have an analysis of law relating to Sikh marriages in India. I am Dr. Shiva Sharda. Today we will have the discussion which is divided into the following scheme. First we will have a brief overview of Sikhism, then we will discuss the main features of the Anand Marriage Act 1909. Then we will move on to the challenges in the Sikh matrimony, followed by the legal considerations. After legal considerations, we will have the Anand Marriage Amendment Act of 2012, its main features. Then we will have the introduction of a newly inserted section 6 in the Act, followed by the challenges and considerations, and finally we will sum up in the conclusion. So let's start with the introduction. Sikh marriage, referred to as Anand Karaj, constitutes a sacred and significant relationship in Sikhism. This ritual occurs in the presence of Shri Guru Granth Sahib, the holy text of Sikhism, and it demonstrates a profound commitment to a shared existence. For an extended period, Sikh weddings encountered the obstacle of lacking legal recognition. The Anand Marriage Act of 1909 was enacted during British administration to address this issue. Nevertheless, it did not include measures for the registration. Sikhs were required to register under the Hindu Marriage Act of 1955. This generated uncertainty, particularly for the Sikhs overseas who were officially classified as Hindus. In 2012, the Indian Parliament amended legislation permitting Sikhs to register their weddings under the Anand Marriage Act. This legal acknowledgement is essential for safeguarding couples' rights and interests, guaranteeing their access to all the legal benefits. The Anand Marriage Act was changed to incorporate registration rules conforming to Sikh norms specified in the Sikh Rahat Maryada. This amendment was significant as Sikhs had encountered difficulties obtaining legal recognition in the marriage registrations for almost a century. The Anand Marriage Amendment Act of 2012 enables Sikhs to register their weddings under the Anand Marriage Act, so matching their legal status with their cultural identity and addressing a long-standing issue. However, the act was repealed in 2015. Now, let's have a brief overview of Sikhism. Students, Sikhism is a religion and a philosophy that originated in the late 15th century in the Punjab region of India. Sikhs, the followers, adhere to the belief in a singular immortal being, the 10 Gurus, the Guru Granth Sahib, the Sikh scripture, the teachings of the Gurus and the rite of the initiation instituted by the 10th Guru. Sikhs renounce loyalty to other faiths. Male Sikhs adopt Singh, that is lion, and females adopt Kaur, that is princess, as surnames, contesting India's caste structure. They prioritize the welfare of all and actively participate in worldwide humanitarian assistance. The Punjab region is the ancestral homeland of the Sikhs. Globally, there are over 25 million Sikhs, with 80% residing in India, with substantial communities in Canada, the UK, the US, Australia and several other nations. Sikhism advocates for devotion to God, integrity, compassion, humility and kindness. The sacred text is the Shri Guru Granth Sahib. Sikhs uphold the concept of singularity of God encapsulated in the phrase Ek Omkar. Now coming to the Anand Karaj. Anand Karaj is the Sikh matrimonial ritual, a momentous and celebratory occasion in Sikh tradition. Anand Karaj translates to blissful union or joyful ceremonial occasion. It was begun by Shri Guru Amar Das with the significant addition of Lama hymn by Guru Ram Das ji. During Anand Karaj, the couple circumambulates the Guru Granth Sahib, the sacred text of Sikhism, signifying their dedication under divine guidance. The ceremony entailed encircling the Guru Granth Sahib Ji to emphasize the spiritual dimension of the union. Students, in Sikh marriage, it is believed that couple are genuinely united when they become one light in two bodies, symbolizing a profound spiritual bond. The objective is for the couple to share similar thoughts and emotions embodying Ik Jyot Do Murat, which translates to one spirit in two bodies. This signifies the profound connection of their souls inside the institution of marriage. Students, Anand Karaj transcends to a mere social occasion. It embodies Sikh ideas highlighting a devoted existence anchored in robust values. This is a magnificent method of uniting souls in matrimony initiated by Shri Guru Amar Das Ji and formalized by Shri Guru Ram Das. In Sikh marriages, there are significant steps, customs and principles. Sikh marriages underscore the principle of equality between the spouses. Marital unions do not take into account caste or social standing. The custom of providing or accepting dowry is disapproved. Sikh adheres to monogamy, viewing husband and wife as equals. Remarriage is permitted, including for widows and widowers. The religious ceremony must occur in a gurdwara or at the bride's residence, excluding commercial venues. The wedding expenses should be equitably distributed, fostering shared accountability. Sikhism advocates for a marriage as a pathway to spiritual and personal fulfillment. Now, coming to the next section, we will discuss the main features of the Anand Marriage Act 1909. The Anand Marriage Act of 1909 is commonly called as the Sikh Marriage Act. This legislation acknowledges and legitimizes marriages conducted by the Anand Karaj ceremony, a religious rite signifying blissful union. This ritual is deemed sacred and founded on Shri Guru Amar Das Ji and Shri Guru Ram Das Ji doctrines. During this ritual, Shri Guru Granth Sahib is positioned at the center while the couple circumambulates it 4 times accompanied by the lava chants. In 1909, the acknowledgement was granted and no registration process was established. In 2012, following the efforts by the Sikh community, Parliament enacted a revision to the Anand Marriage Act of 1909, resulting in a comprehensive act with registration stipulations. Despite the passage of almost a decade, numerous states have not executed the modifications, as the authority to formulate registration process resides with the states only. Currently, some state governments are persuading their Sikh inhabitants to register their weddings under the Hindu Marriage Act of 1955, which is regarded as a secular law and is purportedly modelled after English law. The Anand Karaj ceremony may be conducted in accordance with the Hindu Marriage Act 1955 and recorded following the established method. Students, the Special Marriage Act of 1954 share numerous parallels with the Hindu Marriage Act, thus ensuring that Sikh marriage practices align with the legal statutes, harmonizing law and custom. However, it is important for us to understand the challenges in the Sikh matrimony. So, let's start that. First, the divorce is prohibited in Sikhism as adherents are committed to lifelong marriage as discussed earlier. This commitment is essential. Nonetheless, it presents a barrier for couples unable to overcome their conflicts as they cannot legally obtain a divorce according to Sikh tradition. Discussions are ongoing regarding this matter. Some advocate for its removal while others uphold it as a tradition. This exerts a pressure on legislators as the Sikh community is advocating for distinct personal legislation for their faith. The authority to permit or prohibit divorce resides with the legislators. Community intervention. Couples encountering difficulties frequently seek assistance from the community, specifically from an organization known as Panj Pyare. Although community assistance is beneficial, certain individuals may perceive a diminution of privacy in their personal affairs when others intervene. Students, now let us discuss some challenges of interfaith marriages. Marrying a Sikh in accordance with the Sikh traditions might provide difficulties for individuals from various religious backgrounds. The stringent regulations and demands in Sikhism provide challenges for individuals contemplating complete commitment to Sikh lifestyle. This poses difficulties for those who do not fully concur with or adhere to all Sikh principles. Sikhism necessitates a comprehensive and regulated belief system for involvement in the Anand Karaj ritual. Students, now let us discuss some legal considerations. The Anand Marriage Act of 1909, enacted by the British Imperial Legislative Council, formally acknowledges Sikh weddings performed under the Anand carriage ceremony as discussed earlier. This legal framework respects Sikh beliefs and practices, offering legal recognition for marriages conducted according to the Sikh traditions. The act applicable across India, save for Jammu and Kashmir, has limits. It does not encompass weddings involving individuals outside the Sikh faith or those annulled by the court. Please note, or those annulled by the court. Furthermore, it does not include procedure for marriage registration, posing difficulties for Sikhs who frequently had to register under the Hindu Marriage Act of 1955, resulting in a conflict between their cultural identity and legal status. Therefore, in response to these issues, a Sikh BJP member of Rajya Sabha introduced a bill in 2004 to alter the Anand Marriage Act of 1909. In 2011, after 7 years, Sikh scholar Dr. Birinder Kaur submitted a case to the Supreme Court to prohibit the application of Hindu marriage law to her community. Please see Birinder Kaur and Another versus Union of India for the details. The Supreme Court posed a significant inquiry to the administration over the potential designation of the legislation as the Buddhist Marriage Act and applicability to other 3 communities. Students, the 2012 modification to the Anand Marriage Act enacted by the Indian Parliament sought to address the registration issue for Sikhs. The modification aimed to facilitate the registration of Sikh weddings under the Anand Marriage Act, so aligning legal recognition with Sikh rituals and enabling the merging of cultural identity and legal status. Students, now let us discuss some main features of the amendment of 2012 in the Anand Marriage Act. Coming to the prefatory portion, the Anand Marriage Act 1909 was instituted to clarify the legitimacy of the marriage ritual prevalent among the Sikhs known as Anand. This type of marriage is referred to as Anand Karaj and has been observed among the Sikhs. The enactment was passed to validate such weddings due to credible concerns that uncertainties would arise regarding them, perhaps leading Sikhs to encounter significant challenges and suffer substantial costs from the lawsuits in the civil courts. The department-related Parliamentary Standing Committee on Personal, Public Grievances, Law and Justice has recommended the inclusion of a section in the Anand Marriage Act of 1909 to facilitate the registration of Sikh marriages in 2007. The committee indicated that there was an agreement on the idea and directed the legislative department to initiate amendments to the Anand Marriage Act of 1909 to facilitate the registration of weddings conducted under the Act. Students, additionally, multiple representations were received requesting revisions to the Anand Marriage Act of 1909 to mandate the compulsory registration of Anand Karaj marriages. In the light of the Standing Committee's suggestions and various representations, it was recommended to change the Anand Marriage Act of 1909 to facilitate the registration of Anand Karaj marriages conducted by Sikhs, thus ensuring its evidentiary validity. Consequently, it deemed essential to revise the Anand Marriage Act of 1909 to facilitate the registration of Sikh weddings. The bill proposed that the parties to a marriage registered under this act shall not be obligated to register their marriage under the registration of Birth and Death Act of 1969 or any other applicable law following the enactment of the proposed amendments. In section 2 of the Anand Marriage Act 1909, the phrase the Sikh marriage ceremony called Anand shall be followed by the insertion of the word commonly known as Anand Karaj. Now let's have a discussion on introduction of a new section 6 in the 1909 Act. Now registration of marriages. To facilitate the verification of the marriage ceremony commonly referred as Anand Karaj, repeating again, customary among the Sikhs, the state government shall, without detriment to the provisions of the Hindu Marriage Act 1955 or any other prevailing law, establish regulations stipulating that the parties to such marriage, whether solemnized prior to or subsequent to the enactment of Anand Marriage Amendment Act of 2012, may have their marriage details recorded in accordance with the specified conditions in a marriage register maintained by an officer of the state government or a local authority designated by the state government as notified in the official gazette. Next, the marriage register shall be accessible for inspection at all reasonable times and shall serve as admissible evidence of the statements it contains. Certified extracts may be obtained by the parties to the marriage from the registrar upon application and payment of the prescribed fees. Furthermore, notwithstanding any provision in this section, the validity of Anand marriage solemnized shall not be compromised by the failure to record an entry in the marriage register. The parties to a marriage registered under this act are not obligated to register their marriage under any other applicable law including state acts. Furthermore, individuals whose marriage is registered pursuant to this act are exempt from registration under any other legislation. Students, this amendment sought to address registration difficulties encountered by Sikhs, creating a legal structure for the recognition and registration of Sikh marriages under the Anand Marriage Act. Modifications included the formal incorporation of the term Anand Karaj into the Act, aligning it with specific Sikh marriage ritual. Furthermore, Section 3 and 4 were added to delineate exemptions and protect the legitimacy of marriages conducted through alternative customary Sikh ceremonies. Significantly, the exemption for Jammu and Kashmir was eliminated, thereby broadening the scope of the Anand Marriage Act to encompass entire nation. Students, according to Section 6 of the Act, each state is mandated to establish regulations for the registration of marriages under the Anand Marriage Act of 1909. Currently, over 10 states including Haryana, Andhra Pradesh, Tamil Nadu, Kerala, Rajasthan, Delhi, Chandigarh, Himachal Pradesh, Meghalaya, Punjab and Uttarakhand adhere to the Anand Marriage Act, each with its own specific regulations. In 2018, Chandigarh and Delhi instituted particular rules for the Sikh marriages under this Act. Recently, Uttarakhand, Assam and several union territories have also declared their intention to recognize Sikh marriages under this Act. In November 2022, the Supreme Court comprising Justice Ajay Rastogi and C.T. Ravi Kumar received a petition urging the states to promptly establish regulations for the registration of Sikh marriages under the Anand Marriage Act nationwide. In a legal matter, a Sikh couple petitioned Bombay High Court to compel the state of Maharashtra to formulate rules for marriage registration pursuant to the Anand Marriage Act. Despite a decade passing, Maharashtra continues to require Sikhs to register under Hindu Marriage Act. In 2006, the Supreme Court mandated that all marriages of Indian citizens must be registered in the case of Seema versus Ashwini Kumar. Consequently, marriage registration became obligatory for all individuals. As a result, Sikhs were required to register under the Hindu Marriage Act despite its incongruence with their traditional customs. Now, let us discuss some of the challenges and considerations. Students, this inquiry is intricate, encompassing history, law, religion, and constitutional matters. Historically, Sikhs adhered to Hindu laws, but this shifted with the Anand Marriage Act of 1909, which was specifically established for Sikh marriages. Nonetheless, the complications emerged with the enactment of Hindu Marriage Act of 1955, raising apprehensions regarding the preservation of Sikh identity. Sikhism and Hinduism exhibit significant distinctions in their origins, scriptures, worship practices, and the status of women. Sikhism repudiates specific Hindu doctrines such as caste system, priestly rituals, emphasizing equality and the absence of a clerical hierarchy. These divergences underscore the distinctive characteristics of Sikh religious practices. Although Sikhism is acknowledged as a distinct religion in the constitution, Sikhs remain governed by Hindu laws. The Hindu Marriage Act of 1955 applies to individuals who identify as Buddhists, Jains or Sikhs. The Anand Marriage Act encountered issues of applicability prompting Sikhs to register under the Hindu Marriage Act. This situation fosters the perception that Sikhs are inaccurately categorized as Hindus under certain legal frameworks, which raises concerns regarding religious freedom. Students, Article 25 of the Constitution of India ensures the right to practice any religion, creating a contradiction when Sikhs are subjected to Hindu laws. This situation prompts inquiries into the effective implementation of constitutional guarantees and underscores the necessity for legal recognition that honors Sikh identity and principles, which are vital for preserving religious freedom. In the case of Bhagwan Kaur versus J.C. Bose and Sugan Chand versus Prakash Chand, it was established that Sikhs, absent specific practices, are subject to Hindu law. This contributes to the belief among the Sikhs that their distinct religious identity is not adequately recognized in legal contexts. Court cases such as Ashima versus Narendra and Shastri Yagnapuru Shabji versus Muldas Burudardas Vaishya significantly influenced the legal framework. It was highlighted that the diversity of Hinduism renders precise definition nearly unattainable. Hindu law does not delineate who qualifies as Hindu. Instead, it specifies the individuals to whom it pertains. This encompasses those born into or converted to Hinduism, Jainism, Sikhism or Buddhism. The court characterized Hinduism as a way of life transcending conventional religious attributes. The Hindu Marriage Act of 1955 instituted substantial modifications to traditional law, aligning Hindu marriages more closely with the Western contractual model. The Act addresses elements such as consent, divorce, age restrictions, and the prohibition of bigamy. Notably, the legislation no longer exhibits a bias towards males. It diverges from the traditional Hindu law principles and has extensively incorporated elements from English matrimonial law. Sikhism, as a contemporary faith, is amenable to embracing modern laws that correspond with its tenets. Despite assertions of the Hindu Marriage Act's secular nature, the ongoing concern is allegedly flawed classification of Sikhs within the Hindu category. Clarification of this matter is essential for acknowledging the unique identity of Sikhs within the legal contexts. Now, coming to the conclusion of this lecture, emphasizing the Anand Marriage Act and its changes, this lecture ended with the examination of legal aspects of Sikh marriage registration. It discusses the historical challenges Sikh faced in the marriage registration and looks at the important 2012 amendment allowing them to register their nuptials under the Anand Marriage Act. Examined are the legal and the cultural consequences, including court disputes and concern about Sikhs, subjugation to Hindu laws. The lecture considers the advice on the official registration of a Sikh marriage under the amended act, specifying the required conditions and paperwork. The complex issue of Sikhs following Hindu rules is examined, hence stressing the need for legal recognition in line with the Sikh identity. For Sikhs, concerning marriage registration, the Anand Marriage Amendment Act of 2012 brought notable changes. Hindu laws controlled their marriages, hence Sikhs found a formerly amended law to register under the Anand Marriage Act. So, maintaining their cultural identity at the Sikh marriage ceremony Anand Karaj. The lecture emphasizes the customs and challenges connected with the Sikh marriages as well as the complexity of following Hindu regulations. Though ongoing legal advocacy is still vital despite the 2012 amendment's goal to improve registration procedures. Though it removes the Sikh label, registering the Sikh marriages under the Hindu Marriage Act 1955 is theoretically allowed and raises questions of equity. Maintaining the unique nature of Sikh marriages and guaranteeing fair legal recognition depend on creating separate laws for them. With this, we come to the end of today's lecture. Thank you very much. Have a good day.